that are going to give them the best answers on both sides. Right. And it's very difficult for the juries, for a jury to decide whether expert A or expert B is more credible. So I don't think it really works that way. I think you have to have a screening panel of physicians to decide whether or not malpractice has occurred.
Mike,
yeah, and I disagree with that. I'm not vehement about that. I mean, I think that there could be a place for that within a system. And in fact, I know that most hospitals do have peer review panels now, but of course the proceedings of the peer review panels are secret.
Right.
We're not allowed to get any of the proceedings of the peer review, so we don't know, and the public doesn't know, and the patient doesn't know.
Right.
Whether or not the doctor has been found responsible. And what we've found also is, of course, most patients who actually do experience malpractice, I think, and I've almost never had anyone come in and say they've admitted it. And I almost have never brought a case where the doctor comes in and admits he committed fault, no matter how dramatic the fault is. Yeah. This system does make doctors defend things even when they shouldn't.
That's right. I agree with you fully. The system makes the doctors very defensive, and because most doctors feel it is not fair. They feel it is not equitable, and the system is tilted against them. And I've had 2 malpractice suits against me. One of which was dismissed, and one of which went to trial. The one that went to trial, it took 6 years before it went to trial. I had 6 weeks where I had to be in the court every day. It was dismissed by the jury after 20 minutes of deciding, and they told the judge they could not see why this case was brought. They thought it was a miscarriage of justice. They took us out to lunch afterwards because they felt so badly for us. So do you
think the jury did the right thing in that case?
I think the jury did the right thing, but I don't think
the jury does the right thing.
But I don't think the system did the right thing. I went through years of testimony, giving depositions, reading depositions, hours and hours and hours spent on this case. I went through all kinds of emotional trauma. Then I had to spend 6 weeks in the courtroom. I'm finished. No, I don't get anything for the time that I spent. I had to defend myself against a case without any merit, and I get nothing out of it.
And you dread having to go through something like that again, right?
I can't sue the patient, and I can't sue the attorney who brought the case for what I feel was malpractice on their part.
Well, let me say this, that in the past, there had been some, and I mentioned earlier how few malpractice cases are actually brought, 272 last year, and that's down by about a third. We're about 360, 370, and one of the reasons for that is that Connecticut has adopted a system for monitoring malpractice so that doctors do not experience unwarranted suits. And what we have is a system now which says that before a suit can be brought, there must be an actual certificate filed by another doctor in the same specialty attesting to the merits of bringing the case. Now, let me just say something.
Let me just say, we had a certificate of merit.
It's different.
We had a certificate of merit filed against us by, I'm a neurologist, a physician who is an internist in Wisconsin. They got somebody to file a certificate saying that the case was meritorious. We had not gone through the standard of care. This was a doctor who subsequently...
You're dealing with an older system. The system I'm talking about just went into effect 3 years ago. The system you were talking about was a system which said a lawyer had to certify that there was merit to the case and that he had to have an expert witness. So in that case, he may have had an expert witness who was not qualified, but everything has been changed in the last 3 years.
What's the new system, Mike?
The new system is you must, before you can file, there has to be a letter from a physician in the same specialty or related specialty which deals with the same issue, and it has to be filed with the court before a case can be filed.
That happened in my case.
And Bob,
I don't know why.
It happened in my case.
It didn't go into effect 6 years ago.
It happened in my case. They filed a certificate of merit beforehand. It was not in my specialty. It was an internist rather than a neurologist. It was someone who had no experience with the type of problem that we had. And then this particular doctor lost his license because of Medicare fraud while the process was still going on.
You were a victim of a bad lawsuit the way many, many thousands of people are victims of medical malpractice. Right. And the people with victims of medical malpractice live the rest of their lives with it, and live as paraplegics, as brain damaged people, dying of cancer and dying of other illnesses that they didn't have to die of. So that, although I feel sorry for you for having to undergo that, that doesn't mean that you deprive people of their right to a jury trial, which is in the Constitution of the United States, but deprive them of ability to get adequately compensated for their injuries.
How do we make it more equitable for the physicians?
I think that what I'm trying to say is I think Connecticut has gone a long way toward making it more equitable by having what is the new system. And even though you're saying that under your case, some doctor who was not qualified, who was not in your specialty, filed a certificate, Connecticut has already changed that and has a certificate of merit signed by a requiring a doctor in your specialty to file that certificate. So in other words, we're not doctors against lawyers here. We're not patients against doctors here. There are doctors on both sides of the cases, and there are lawyers on both sides of the cases. You know, right. I mean, and there are patients, and the patients are sort of in the middle.
But you know, yet even though the system is supposed to work,
you guys are doing a good job. Wait a second. Okay.
Even though the system,
this is a tough issue, I know.
Yeah. Even though the system is supposed to work better now, why is it that 75 or 80% of the cases that come to trial are found for the defendant?
Well, I'll tell you the reason for that. The reason for that is that 90% of the cases are settled, so that the ones that actually end up going to trial are the ones that are really contested, and they're usually contested on two grounds. One is that that either they were not meritorious, which is there are some, and some are in the middle, which are difficult to decide, and you have to leave that up to the jury. And some they can't agree on amount. That's why cases go to trial. So and that is fewer in Connecticut than 10% of all cases filed. 90% of them are settled. So, and that's because
settled or dropped. Or
dropped. But I'll tell you what cases get dropped. You're a patient in an operating room.
Right.
And something goes wrong inside the operating room. You don't know whether it's the anesthesiologist who did it, or the surgeon who did it, or the circulating nurse who did it. How do you know before you file suit which one did it? You look at the records, and the records are blank because they all know something went wrong, and they're not going to incriminate themselves.
Mike, quickly, folks, we got 30 seconds for this. 30 seconds for this first segment. Whew, I need a shower. No, but you've heard, you know, some of the good arguments on both sides. Two very informed guests, and this is going to require a lot more talking. Listen, we'll see you again next week, and we're going to continue with this great discussion. Stay well.